I wanted to talk about protecting inheritance in case of divorce. And there's a couple of things that I want to say in advance, especially if there's clients, and I see some of my clients are on the webinar. And oftentimes, I would say 99.9% of the time, we have our clients' documents, whether they be a will, revocable trust, irrevocable trust, and in a descendant's trust to the children. And what we explain to people is that now that taxes are not, except for high net worth clients, and we have to separate that, and I will talk about that. Most people are concerned about how do I protect my assets for my children. 50% of marriages end in divorce. And they're not just young people, even older children. We have what we call the gray divorce, people over 60 years old getting divorced. How do I protect my heirs in case of divorce? How do I protect them from general creditors? And if they need Medicaid or care down the line. Remember, if people are living longer, absent COVID, the largest growing segment of the population are people over 90. That means their children may very well be in their 60s and 70s when the parents die. So we use a descendant's trust in order to protect those assets for the children. And in most cases, my question to the client is, do you want to protect your heirs from themselves or from others? And overwhelmingly, it's that they want to protect their heirs from others, not from themselves. So in a case where you have a child that has a drug problem, an alcohol problem, a spending problem, or some creditor problems already, you are usually then trying to protect them from themselves. In that case, you would name a trustee for them, and you would have certain restrictive provisions on what the money could be used for, and you would leave it in the discretion of the trustee. But overwhelmingly, my clients say, no, I don't want to stop my children from getting the money. I just want to stop other people from getting it from them. And in that case, usually they want to make it easy and simple. So in our typical descendants trust, we allow the child the income because they can act as their own trustee. They can take the income from the trust and it would still have creditor protection. The only thing that would not have creditor protection would be that income. So on the average estate, not high net worth clients, the child having the income, they're not too worried about. They want to make it easy for the child to invest the money in the trust and take whatever income comes from it. In addition, as an interested trustee, the child can take distributions for health, education, maintenance, and support, what we call an ascertainable standard under the Iras code. In that case, again, they can make payments for anything that includes the health, education, maintenance, and support. If they want something for a cause other than HEMS, right, then they can appoint an independent trustee who then can authorize them to take a lump sum, which is not for health, education, maintenance, and support, even to the point where they could terminate the whole trust. And for majority of clients, that works. Where it gets a little bit more difficult is if you have high net worth clients. So now you're talking about a lot more income that is available for creditors, because if the child gets the income, then it's subject to creditors. So then we're talking about making more restrictive provisions. Now that is not for everyone. That's the point I want to make. Not everyone is concerned with that. And there may not be enough money. But for those that are, that's what this lecture is about. How to protect the trust if you have a child who really is going through a divorce, and to how can it be drafted. Typically, what we're talking about is a third-party trust. That means it's not the child's own money. And let's call that the beneficiary spouse in a divorce. So they are the beneficiary of a trust, usually created by a third party and usually by a parent or grandparent. Okay, so let's make an assumption for the purposes of this discussion. A parent creates a descendants trust for their child, and the child's going through a divorce. As I already said, if the child's entitled, the beneficiary spouse is entitled to income, that income will be a countable asset in terms of maintenance and support, because they do get the income from that if it's mandatory. If it's discretionary, then that's a question that has to be determined. By the way, in terms of divorce, you also have to look to state law. Don't ignore what state law is in terms of what happens in a divorce proceeding. It's different in every state. But typically, if the child is getting income from the trust in New York State, that would be considered part of their income in terms of support. Even though a creditor can't get to the trust itself, including a spouse, the income that the beneficiary spouse earns will be considered in that. And then the other thing is, can there be distributions? Now, if you have someone who has, especially for a high net worth client, a lot of assets in the trust, one of the things will be who's the trustee. If I were going to try and make this ironclad because I'm worried about this divorce, I would not make the beneficiary spouse the trustee. I would choose someone. Now, there are different levels of who you can choose. You could make the child their own beneficiary for health, education, maintenance, and support, but I don't think it has as much creditor protection. You could name a family member, or you could name an institution. I would say in terms of naming an institution, you're really talking about a much larger trust. Institutional trustees typically have a minimum of the assets that they will manage in a trust. So for the average person, typically you're looking at someone other than the beneficiary to be a trustee, or they could be a co-trustee so that they can be involved in the investment of the assets, but not have any distribution powers for themselves. Another thing that you might consider, and this happens in maybe family businesses or family property where each child gets a share, it may make sense to do a trust and name each one of them a beneficiary of the trust. I think that has stronger protection if the beneficiary spouse who's getting divorced is only one of several beneficiaries in the trust. I also think the intent of the parent is also important. Now, I've seen trusts that are written where they say that the grantor's intent is that it would benefit family members and descendants and not be part of a marital settlement. The other thing is sometimes a trust does have a provision for spouses of beneficiaries, maybe a definition of a spouse, and it would be a spouse who is married to the person at the time of the distribution, and that may make it harder for them to get at if they're no longer a spouse, or if you have a definition where if they're not part of a divorce settlement. Remember, a third-party trust is created by someone else, so it's really their intent that is interpreted by the court, and then what is mandatorily must go to the beneficiary spouse and what is discretionary. And obviously, if you have a third-party trustee who has absolute discretion to distribute money to beneficiaries and multiple beneficiaries in a family, it would be much harder to get to that than if it's one trust for one child. So that's something to think about, especially if it's property that the whole family enjoys. First-party trusts are a little bit more difficult, and that I'm talking about trusts that may be a husband and wife, or, by the way, it doesn't matter, it doesn't have to be a husband and wife. This goes, same-sex marriages. In terms of spouses, when they create a trust during their life, one of the questions is that marital property? We see that right now we're doing a lot of spousal limited access trusts to save the federal exemption this year. And then how do you define spouse in that document? In a lot of cases, what we're doing, and again, with full disclosure to both spouses, if they're both our clients, is you could say that the spouse and the beneficiaries are beneficiaries of that trust as long as they're still married, right? I have seen cases where spouses have created what we call an ILIT, an irrevocable life insurance trust. And the courts have held, at least in one case, it's a New York case, that it was created for a valid estate planning purpose. Neither spouse was a beneficiary, and they would not disturb it during the marriage. The other thing is, in terms of third-party trusts, and that's in terms of drafting the trust and how you would draft it. And we can draft it more restrictive depending on what the situation is. The other thing is in terms of administering trust. So now I have high net worth clients that are entitled to distributions for health, education, maintenance, and support. And maybe they even have a third-party trustee. One of the things that we want to look at if they are going through a divorce is what is it used for? Because I have seen cases where it may be used to pay for the kids' camp or schooling or family vacations or second homes that may influence the judge in a divorce to make, although they can't make a determination as to the assets of that trust. They can't award anything to the spouse. They can make it up with other marital assets. So if that trust is used to pay a lot of the family expenses, you're setting a standard of living that the family, the other spouse, and the children are entitled to. And the other thing is in terms of using the trust to purchase real property. Oftentimes I give the example to my clients is that if they leave money in a descendant's trust for their children, the children could take money out and buy a house. If they take that money out, they buy a house and they buy it in joint names, that essentially is becoming marital property. And again, look to state law, but I'm talking pretty much about New York law. If you buy a house in husband and wife's name, there's an argument that some of that is your separate property, but it creates an issue. One of the things I might say is if your parents left you a trust, a descendant's trust, and you can get a lump sum with the permission of the independent or third-party trustee, then maybe what you should do is have an agreement with your spouse that any monies that come from the descendant's trust to purchase a house outside the trust will be paid back to the trust in case of divorce. Now they're freely, it's almost like a post-nuptial agreement where they're agreeing to use the money from the descendant's trust to purchase this house, but yet that money goes back in the descendant's trust in case of divorce. And, I think that makes a lot of sense because it also allows them as a husband and wife or as a couple to own a home together in their names to get the tax deductions. And maybe they can afford that better house because they've taken the down payment from the descendant's trust. But yet that down payment would remain separate property in the case of a divorce. I think that works well. Sometimes I have clients that are the beneficiaries of the descendant's trust where they might buy a second home in that trust, wholly within that trust. Also, typically that trust would be protected for Medicaid purposes and general credit purposes and is not estate taxable upon their death. All good things. So I think that when we leave these assets to children in a trust, the descendants really need to get some guidance on how to set those up and how to make distributions from it and what kind of help they need and how to report taxes and what makes sense in connection with their own estate plan and their health and circumstances. The other thing is anything in that descendant's trust could easily be included as a clause in a prenuptial agreement, that the descendant can reach an agreement in the prenuptial that says anything in that trust is not subject to equitable distribution if they get divorced, notwithstanding any distributions made from it. So certainly that prenuptial or even a postnuptial, if they're already married when they inherit that money, would make sense. It's just hard to get sometimes the descendants to enter into those prenuptials or postnuptial agreements. Now, one of the questions is what happens if you've already created a trust? And the example would be, I have a client who comes to me and says, gee, we did that trust. We did a descendants trust for our child, but they're going through a really, really tough divorce. And we're concerned that these assets will be subject to some sort of settlement. Is there anything the parent can do? Well, under the estate powers and trust law, even an irrevocable trust can be amended provided the grantor and the beneficiaries agree. And so that trust could be amended. One of the things is that amendment only has to be made with the beneficiaries. And typically, for instance, in a Medicaid trust, we have a power of appointment to change the beneficiaries. In a case like that, I might not include the beneficiary spouse as a beneficiary. I may change that under the power of appointment and amend the family trust with other beneficiaries who are not involved in the divorce. And then, of course, you can exercise a power of appointment after it's amended to include the beneficiary spouse. Again, I have no problem with doing this because it's really the intent of the parents which counts. And they have the right to amend that trust any way they want, whether their child's going through a divorce or not. And oftentimes I have clients who come in and they tell me that their parents left them assets outright. They're going to inherit a great deal of money and they don't want to do a prenuptial. And they're concerned about what will happen to those assets once they inherit them. Even though even under New York law, they're separate property, what happens after that is of concern. So it's not uncommon for me to have them have their attorney, their parents' attorney, call me and talk about amending those documents to make the trust for the descendants stronger and give them greater creditor protection. And so that's fine as long as the grantor, in this case, I'm calling it the parents, are alive and well and can make those type of amendments to their trust. But what happens if they're deceased and now the trust exists and it has these provisions? The other thing we can consider doing is decanting the trust. And decanting is logically for lay people, sort of like you decant wine, right? You pour wine and you leave the bad residue in this, the decanter, and you put it into a new decanted vase that doesn't have all the bad stuff. So if you want to change administrative provisions and things, there are some limitations on what you can do. And there's two ways to decant: one under the New York statute and also within the document itself. So every trust that we create, we have a provision that allows the beneficiaries or an authorized trustee to decant into a better trust, and they're very liberal. And what the statute says is that you can decant under the statute or under the document itself. So we don't want to rely upon the statute. So we have a very nice liberal decanting provision in all our trusts. And that's another way in which you can change the trust even after the grantor parent dies. So that's another way you can fix the trust. So all of these can be used. And if you have a beneficiary that's going through a divorce, or if you are the beneficiary spouse that's going through the divorce, you need to take a look at those trusts in which you're a beneficiary and see if there's anything you can do. In terms of future protection, obviously doing a prenuptial agreement is very important. Also, there are states like Delaware that has domestic asset protection trusts. While the general rule is that spouses are not prevented from attacking a domestic asset protection trust, that only applies to spouses that existed before you created the trust. But typically, if you do this DAPT, we call it DAPT, before the marriage, that spouse would be prevented from attacking that trust. So that's something to look at. And that comes up when we have clients that have been through, and oftentimes, a nasty divorce, and they're concerned about, well, what do I do to protect myself in the future? Of course, one thing is don't get married, right? But the other thing is do a prenuptial agreement, maybe look at domestic asset protection trust. Certainly if it's a high net worth individual, that makes sense. And if they have, their parents are leaving them money, to urge their parents to amend the documents to give them stronger asset protection. So Michelle, that's really my presentation. Are there any questions? Maybe I can see here. Okay, I'm looking at a question here. Is it better to set it up before marriage, and does an irrevocable trust protect one's assets prior to marriage? Okay, so the question here, is it better to set one up before marriage? Well, certainly in the case of the domestic asset protection trust, it's very important to set it up before the marriage. But even if you don't have a domestic asset protection trust, you have a New York trust, it's an irrevocable trust, setting it up prior to the marriage, yes, it will protect the asset. You're clearly not using marital assets because you created it before. And it's very easy to say, hey, this trust is one of my separate property assets, and do a prenuptial agreement that completely excludes that. So I think it actually does help to do that before the marriage. Another question, how would one protect IRAs and checking accounts? Is a trust stronger than a prenup? Well, the problem with IRAs is that you can't put IRAs in a trust. So if you have IRAs and and even if it's an inherited IRA, the Supreme Court spoke to that a few years ago. While typically IRAs are protected for an individual who earned it or their spouse, it's protected from all other creditors. When your children inherit that IRA, it's an inherited IRA, it does not have creditor protection, not from spouses or any other creditors. You could have payments of the trustees to a trust. And again, that's an inherited IRA. You can leave it to your child's descendants trust that's created in your document. That will protect it. Just the individual themselves can't protect it if it's their own their own IRA from a marriage. Is it stronger than a prenup? I would say, again, if you leave assets to a descendants trust, it's strong, and having a prenup that specifically says that those are not counted as assets in case of divorce makes it even stronger. The next question, what do you consider high net worth? Well, a high net worth would probably be someone with, I mean, when I'm talking about high net worth clients, usually over $5 million. But again, that's the question, like someone asked me, well, does it pay to protect my house? And, you know, that's all I have. Is it worth it to do a trust to protect a house? But meanwhile, even if your house is worth $350,000, you have to answer your question. Do I want to protect that? Chances are yes, whether you're a high net worth or not. It's just when I say high net worth, I'm talking about if you inherit an asset that has $350,000 in it and that earns 2% a year. That's not going to be a big argument in a divorce proceeding than a trust that has millions of dollars that's in a family trust that really supports the beneficiaries, right? There's a lot more there and a lot more incentive to attack that trust and spend the money to attack the trust. And that's the only reason why I separate high net worth from the average person, because someone that inherits typically from not a very wealthy family, there's not going to be that kind of money to fight the trust agreement. The other question is, how do you classify someone as high net worth? Again, where do you draw the line? I think more of the question is sitting down with the client, finding out what's in the trust, finding out what it's used for, using the criteria that I have, finding out what the spouse might have, because now I'm assuming that someone's coming to me and saying, listen, I have this descendants trust that my parents left me. I'm going through a divorce. Is it at risk? And what can I do? And so whether I decide it's high net worth or not, doesn't matter. More important is the discussion. And is it something that the spouse is likely to go after? And what can we do about it? And that's why it's hard to give a seminar that gives these rules of thumb, because they don't really, it's really specific to each person. And I always say to people, that's the difference between reading something off the internet or getting a form off the internet, because every fact is crucial. And so really that's the question is, hey, I have this trust. Is it at risk in my divorce? And lots of times we work with matrimonial attorneys to make those kind of determinations. Michelle, you want to say something?
Yeah, we're getting some repeated questions, so I'm going to try to condense some of them for you, if that's okay.
Sure.
So one is, are trusts protected from state and federal inheritance?
Well, again, depends. It depends on what kind of trust. So now we're outside the realm of divorce. And then you're talking about, I'm assuming if your parent leaves you money in a trust. The question is, what is their taxable estate? Right now, New York State, the New York State maximum is $5,930,000, and the federal is $11,700,000. If it's beyond that, then they're taxable. So I can't, that's not a one size fits all answer.
Sure. The second question is, does a descendants trust cover a friend?
I don't understand that question. I guess the question is, can you leave money to a friend in a trust? You can. We would probably call it an inheritance trust rather than a descendants trust, because a descendants trust talks about your bloodline, right? So if it's me, it's my children, my grandchildren, great-grandchildren along my bloodline.
Sure. A last one that we had earlier was, how often should I review my estate plan?
Okay, well, typically, again, it depends on your age. What I tell people, every 3 to 5 years, or if there's a change of circumstance. So certainly, if you have an estate plan, you're going through a divorce, you should be looking at it, right? If there's a change in health, there's a death, any life-changing situation. And of course, I always tell my clients, we're happy to review it at any time. It's very important that you stay up to date. You would be, or maybe you wouldn't be surprised how many clients come in and they say, here's a will I did when we bought our house, and my kids are now married and have children of their own. And, they've got guardians in the will for their children. So certainly more often than that. And I would say every 3 to 5 years. Now, stay tuned. You're going to be hearing more from us. There's a lot of proposals now for the reduction in the federal exemption, which is currently $11.7 million. I don't know if you've heard this last week. Bernie Sanders and some other Democratic senators have put together a bill to reduce it to $3.5 million. Which is going to be a drastic change. And it's one of the reasons why we are doing a lot of trusts now, to try and use that 11.7 million before it goes down. And I'm sure, Michelle, you will be doing plenty of seminars on that.
Yes, we will. We always like to keep up to date and current with what's going on. So I appreciate you doing them. It looks like that this wraps up our questions for today, Nancy. Thank you for presenting. Just please keep in mind to everyone who's attending that recordings of all of our webinars, including this one, are found on our website at bernerlaw.com, and as well as our YouTube channel, also under Berner Law Group. So again, thank you for joining us. Nancy, thanks for presenting.
Great, thank you.
Okay. And